Court is calling 2020 CR 5583 State versus Erica Ann Arevalo. Could I have parties announced?
I think I'll reinstate.
Lindsay Shaw for Ms. Arevalo.
And are you Ms. Arevalo?
Yes. Yes, madam.
All right, did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and State's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney?
Yes.
And did you understand it?
Yes.
Okay. Are you the same Erica Ann Arevalo who was placed on deferred adjudication in 2020 CR 5583 for the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 to 200 grams on January 13, 2021 for a period of 5 years? Is that you?
I'm sorry. So I was going off of, this might be my mistake. On the front page of the MTR, it shows just she's on for
V1. Whoa, hold up. Did you catch that legal fumble? Even the court clerk seems confused over whether this is a straight possession case or one with intent to deliver. That difference is huge. One carries a lighter sentence. The other could land you serious prison time. So when even the court summary doesn't match the charge, it raises questions about how closely this case has been tracked. Ever wonder how often paperwork mistakes affect real lives?
straight possession.
No, it's possession with.
Well, I see that now. I'm sorry to interrupt you.
Do you need to confer?
I do, because on the first page of just the MTR, not that, but the court summary, it showed that it was just straight. No, the from probation, the court summary.
Okay.
It showed, yeah. So I only discussed the fact I thought it was a second degree. So if I may, I'm sorry.
Yes. No problem. It happens. All right, we're back on the record in 2020 CR 5583 State versus Erica Ann Arevalo. Can I have parties reannounced, please?
Lindsay Shaw for Mr. Arevalo.
All right, Ms. Arevalo, you reviewed the motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney?
Yes.
Did you understand it?
Yes.
Are you the same Erica Ann Arevalo who was placed on deferred adjudication in 2020 CR 5583 for the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams on January 13, 2021 for a period of 5 years? Is that you?
Yes.
All right, state.
State's going to be pursuing a violation of condition number 5 in Dare County, Texas. The defendant, Erica Ann Arevalo, the defendant there failed to report to the supervision officer as directed for the months of January, February, March, April, May.
Let's pause here. The judge just made it crystal clear. Pleading true to this violation opens the door to a life sentence. That's not courtroom drama, that's a legal nuke. And yet Erica still agrees. Think about that. What pushes someone to accept that risk? Desperation, responsibility, or just surrender?
June, July, August, September, October, November, and December 2024 in violation of condition.
How do you plead to that? True or not true? Any objection to the waivers?
No, Judge.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 5 years or 99 years or life in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of...
This part hits different. You hear the defense weaving a narrative of survival. Single mother, caretaker for a disabled parent, a special needs grandchild, holding down a full-time job. The courtroom isn't just about laws. It's about lives stacked with burdens. What would you do if survival meant missing probation check-ins?
Condition number 5. Now, do you still wish to plead true, knowing that I could send you to prison for life?
Yes.
All right, the court will find violation of condition number 5 true. Is there a proposed agreement?
Judge, there's not. State is asking for revocation, given the defendant's plea true and in compliance with reporting on conditions of probation.
All right, and defense, what are you requesting?
Judge, if you look at the court summary, probation was recommending SATIF. In this case, we are asking that the court consider something lesser than sending Ms. Arevalo to prison. we obviously, by pleading true, she understands that it was wrong to not report for over 2 years. But I would like to point out from January of 2021 until July of 2023, she did report. She was reporting. She did complete the outpatient treatment program, and she was holding down a full-time job. That job, which she still has, well, did have until she was arrested last month. She's a full-time cashier at a Shell gas station. It's the same job she had when she got this probation. When she stopped reporting in July of 2023, and I'm going to have her speak to the court, but she sort of got tasked with helping take care of her disabled mother. She's also been helping her grandchild, helping take care of her 5-year-old granddaughter who has special needs. She has a feeding tube. There's a lot of issues going on. And so she put that above taking care of herself and doing what she was supposed to do by reporting to probation. She has no criminal history besides this felony case. She does not have any other felonies. She's never been on any other type of deferred adjudication, and she's never been to prison, obviously. So we're asking the court punish her by sending her to a treatment facility, but give her a second chance before she's gets a felony conviction and has to go to TDC. And if I would like to call Miss Arevalo.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record. All right, you may proceed.
Okay, Erica, I want you to tell the judge, why should she give you this opportunity? Why should she not revoke you and continue you on probation? Can you tell the court?
You can give me a second chance. I'm more better out there of service out there in the world than I am in prison. Never been to prison. This is actually my first time ever being locked up this long. I'm actually I did a whole 180. That was in 2020. I work now. I am actually a grandmother. I still take care of my kids. I still, my son lives with me. I help my mother because she's disabled. My brother was her.
She said, "I don't know anybody who's a prison person." And honestly, that line slaps hard. 'Cause no one grows up dreaming of becoming that. But the judge flips it immediately, because actions carry weight. This is the raw dance between human empathy and cold legal standards. Do you think the court should lean more on compassion or accountability?
Provider, but then he passed away like 3 months ago. So I've been having to help my daughter with her special needs. She's blind and eats through a feeding tube, so I also have to help her. I'm a babysitter for my other daughter while I'm not working. So I want the felony on my record because then it would be harder for me to get a job. So if you could just put a chance on me again, I'm actually a lot better out there than I am here. And I've never, not even a criminal, I've never even...
No, I mean, you had drugs that you intended to deliver. They were in baggies. And what I can tell you is everybody in the box will tell me that they're better in the real world than being in prison. And one of your conditions of probation that you just testified to violating is that I ordered that you were not to have unsupervised contact with minors and you're babysitting. And the reason why I ordered that is because you have possession with intent to deliver drugs. And it was a lot of drugs.
No, I mean, that's not the reason why I totally dropped all of that when my grandkids came up, because how am I going to help them if I'm in prison? So that's basically...
I mean, all you had to do was report.
I mean, I've been taking care of everybody else besides myself.
So honestly, basically, you haven't been doing probation. You know, a lot of people feel as though when they're on probation, they're supposed to report and do certain things. Those are called their conditions. And they're just like, well, I know I didn't do anything on probation, but I didn't pick up any new offenses. I'm just out here living my life. If that's the case, then you're not really on probation because you're not reporting, you're not doing anything that you're supposed to do. You're just living your life. And when people come before me and they say, I know I haven't reported for over a year, which you haven't reported for over a year, but I didn't pick up any new cases. Do you know that is not really saying anything, because there are a lot of people who are not on probation and who haven't picked up any new cases. That's like the bare minimum. Don't pick up any new cases. Don't, join a gang. So you haven't done anything on probation. What have you done?
I've been working and helping out my family and
No, what have you done on probation?
Here comes the gavel. The judge revokes probation, finds her guilty, and gives her 5 years. But, and this is crucial, she still gets credit for time served and will be placed in a therapeutic community. That's not mercy, it's measured justice. But do you think the system truly helps people turn their lives around? Or just resets them behind bars?
I did that class and I was doing everything until I ended up having to move in with my mom, and then she ended up losing her housing. And I know life is like the dumbest, but actually I've been living life trying to better myself and do if you could just give me, I've never even been to prison. I'm sorry, I don't want this on my record, because then it's going to be harder for me to even get a job when I do get, say you do send me. It's kind of going to be even harder for me to, so if I could, please don't send me to prison. Not a prison person.
I don't know anybody who's a prison person, really. But here's the thing. These are consequences to actions, right? So you're not reporting, there was a consequence to that. You could potentially end up being revoked. And I usually tell people, hey, if you think that some action you're going to take could potentially result in you going to prison, then don't do it. If you think it may happen, then don't do it. And you did it. You didn't report. Nobody's seen you for a year. Everything that you're telling me now, nobody's seen you for a year.
I've had a job for 2 years, so I wasn't on the run. I already started getting child support. I already started getting my income tax.
No, I understand what you're saying, but you're on probation for possession with intent to deliver drugs. That means that you have drugs for selling, and they were packaged for selling, and you were given deferred adjudication, 5 years deferred adjudication, and nobody's seen you. This is what the court is going to do. The court is going to find violation of condition number 5 true. The court is going to find you guilty. The court will revoke. I'll take into consideration that the fact that she hasn't picked up any new offenses, and I'll sentence her to 5 years in the prison, give her credit for any time served, and request the therapeutic community. And there's to be no unsupervised contact with minors. And there's a $1,500 fine, time, and money to run concurrently. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. Good luck to you. Thank you. All right. So here's what the court doesn't understand. There's a new number 1, and there are 2 violations of condition number 41. So why are y'all not proceeding on those violations?
Not aware of why that's, Judge. I was just instructed by the attorney assigned to this case that they just wanted to withdraw the MCR and hold off on proceeding before that new number 1 was ready, since that would probably be the strongest basis to argue for revocation.
Well, y'all need to confer, because here's a violation of conditions number 41. That means that if those are true, there's something that needs to be done, because obviously if that was true, there's something wrong with his UAs, maybe, I don't know. And he's on probation for driving while intoxicated. So do y'all want to talk to probation about that?
We have a little bit, Judge,
Okay.
about potentially altering and amending.
Well, is the defense in agreement to altering and amending?
Judge, we've talked about altering, amending, and adding a couple of conditions.
And what would those be?
ISP, server support meetings, potentially GPS if he is able to bond out. I think the bonds are fairly high on his new cases, but while I think that's unlikely, we put a few conditions in place for that.
Probation? Oh, I'm sorry. So they're saying that they want to withdraw the motion, and they're saying ISP, and,
I just don't know that felony drug court will take him back at this point, Judge.
oh, no, they're not.
Right, so I did recommend GPS, intensive supervision, sober support meetings, and the IVR hotline.
And Judge, he does have the ignition interlock and has had it.
All right.
And the other, I'm just handing that to you, Judge. The other, when he submitted other UAs, Judge, there's other two. So I believe there are 4 total that he submitted, and 2 were diluted. So it was negative, dilute, and then negative.
And I'm not aware of any ignition interlock violation.
I'm not aware of any either, Judge.
All right, so you're asking that the motion to be withdrawn, and of course, the court can't proceed if nobody's presenting any evidence, and the alter and amend. So withdraw motion, alter and amend to include, sorry, you're all requesting full GPS?
One of the conditions, should he make bond, is partial, and we would be asking for partial.
For what purpose? Partial for?
Employee, Your Honor.
All right. What I'm going to do is I'm going to do full GPS. Once he provides proof that he's employed, the court will reconsider.
Thank you, Your Honor.
All right, so there'll be full GPS, waive fees, ISP, and how many sober meetings probation? All right, there'll be 90 sober meetings in 90 days. Is there anything else probation? Just continue with the ignition interlock. All right. Is there anything else you need from the court?
No.
Anything else from either side?
Judge, I'll just ask, are the 90 meetings Zoom or is that in person?
He can do that by Zoom. I believe they have Zoom. If they don't, just let probation know and we'll figure something else out.
You want these in custody?
No.
Okay, so
It's going to have to be when he's, well, I will tell you this. I take that back. I said no too quickly. At the jail, they do have classes that they can take that the court will find acceptable to the 90. Okay. All right. Is there anything else?
No, Your Honor.
All right. Thank you. Thank
Are you
you.
excused?
Yes.
Thanks, Judge.
You're welcome. Thanks for standing in.
Yes.
Hello, Raphael. Good morning. How are you doing today?
Excellent.
Did you survive?
Better now that I am before this one.
Okay. It's always nice to see classmates because in your mind, you're thinking about law school and other things.
Absolutely. Those images also flash through my mind.
All right. The court is calling 2025 CR 0018028 and 2025 CR 0018001B, State versus Early Ramirez Hernandez. Can I have parties announce?
Rafael Alvarez Hernandez.
All right, and we have an interpreter here. If you could raise your right hand, please.
Yes, sir.
Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Bean Abrams, license number 2081.
And I previously asked this before, and I know the answer, but Mr. Leal, do you speak Spanish fluently?
Yes, Your Honor.
And have you been able to communicate with your client about this hearing?
Yes, Your Honor.
All right. Mr. Hernandez, you entered a plea of no contest in each of these cause numbers. In each of the cause numbers, you submitted an application for deferred adjudication. And each of the cause numbers, the state is silent on your application. They're asking that your punishment be assessed at a cap of 12 years. The cases are to run concurrently, and they're taking in consideration 2024 CR 00180, 2025 CR 00180B, 2024.
We proceed. I have a mitigation expert
Yes.
that has interviewed Mr. Ramirez Hernandez, and he's asking me, this is a mitigation expert from MAC, the Management Assigned Counsel, and he asked me to request that he will need additional time to give me a report and provide more information concerning Mr. Ramirez Hernandez's social history and mitigation evidence.
And how much time is he requesting?
He asked me for 30 days.
I understand you. So you want to call him and let him know, tell him that if he has already interviewed him, And this case has been since May 30th is when the plea was entered. So if you want to call him and see if,
He says that, Judge, that he was planning on meeting with him 2 or 3 more times to properly develop that.
I'll give you to the week of July 14th, and he needs to have it done by then.
Oh, yes, absolutely.
So will he have it done by then?
I'm sure.
All right, Ms. Ferguson, recall this for July 14th. All right, thank you.
Thank you.
Welcome. Now, are you both parties ready to proceed on the motion to revoke?
Yes, Your Honor.
All right, the court is calling 2020 CR 8253W State versus Ronnie Benson. Could I have parties announced, please?
Rafael Leal for Mr. Benson.
And are you Ronnie Benson? Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am, but I couldn't read it because I didn't have my reading glasses. So
Oh,
he explained it to me. But I told him, I said, I already been tried on this case.
no, you have not. So what has happened is you're on probation for driving while intoxicated third or more. And there are conditions that are set for your probation. So technically you've pled to the DWI. So that's not what you're here for today. You're not here for a DWI from 2020. What you're here for is they're saying that while you were on probation, you did not do something or you violated some condition.
Yes, it was my doctor. He changed my medicine and I came
No. Here's the thing. That doesn't address these issues because none of these allegations in the motion has anything to do about your doctor. It has different conditions. So what's going to end up happening, if both parties are ready to proceed, the state is going to read what they said you did not do. You're going to enter a plea of true or not true, and then I'll make a decision. Do you understand? All right. So are you the same Ronnie Benson who was placed on community supervision in 2020 CR 8253W for the offense of driving while intoxicated third or more on August 27, 2020 for a term of 6 years? Is that you?
Yes, ma'am.
All right. State.
On or about the 17th day of March 2025 in Adair County, Texas, the defendant Ronnie Benson is in there about to submit to the testing as directed by the court/supervision officer in violation of condition number 2.
How do you plead to that? True or not true?
True.
The state waives the remaining violation obligation.
Any objections to the waivers?
No, Your Honor.
All right. Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 6 years in the prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Judge. Amend conditions. Deny the motion. Amend conditions for weekly leeways for 30 days, followed by monthly thereafter. Intensive outpatient with PCC SCD and documented sober support readings as recommended by TAP.
All right. So what has he done on probation?
Judge, he has been, aside from those violations, he's been compliant to a substantial amount of the conditions. He is, for all practical purposes, not employed where he's paid with money. He's paid with by giving him a place to live and kind of like room and board. That's how he gets paid, and he is SSI of $900 a month. So that's one of he's behind in payments, but that's his economic situation. Most of the, aside from those allegations, Judge, he has a bunch of tests that are negative, and we're asking that the court agree with the recommendation and give him those conditions and place him back on regular supervision.
Probation?
Judge, Mr. Benson was in drug court from May of 2021 to March of 2023. Completion of that program, he did the DWI intervention He has gone through one round of outpatient treatment. He's finished his victim impact panel. He was on the transdermal alcohol monitor. He finished that. He did the required sober support meetings. He completed most of the terms of his probation. It's just
Now this is courtroom wisdom. The judge isn't just lecturing, she's practically coaching. People, places, and things. That's Recovery 101. But it's also a life lesson in accountability. Question for you. Do you think people really change, or do they just get better at explaining their choices?
with these slight violations.
You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Tony Benson.
All right, Mr. Benson, do you want to go to prison?
Oh, man.
Then why are you not doing what's required?
I've been doing everything they asked me to do.
Look, why didn't you submit to the drug testing?
I did everything I could.
No. They said, and you just pled true to not testing. Why didn't you test?
I probably didn't have a way.
Did you call somebody and say, I don't have a way to come in to test?
I believe I told the judge.
No, because I'm the judge. You didn't tell me. All right, but you've completed drug court. That's why you're back here. You're back here and your case was not, usually they will terminate your probation when you complete drug court. But the reason why they didn't in your case is because there is no early termination for DWIs.
That's right.
So
I did everything they asked me.
they asked you to submit a UA and you didn't. So my question is, why didn't you do that?
I probably didn't have a way, or I didn't have the money.
Did you call somebody?
I called, well, not here, I didn't. But when I was in drug court, I did.
All right, probation, what are you all asking for? How often are you doing sober support meetings before you were taken into custody?
I was just doing probation and doing UA and reporting every month.
All right, so here's the thing. When you're on probation and you have a drug or alcohol problem, you have to stay vigilant. Otherwise, you're going to backslide. And it starts by missing a UA and not telling somebody about it, not picking up the phone and giving them a reason why you may not be able to make it. And then the next thing you know, you look up and you're back where you were before. And that's what's happening to you. Now, if you want to go to prison, I will send you to prison today for 2 years. You'll be done. You'll get credit for any time that you successfully completed inpatient treatment. Otherwise, you're going to finish this probation. What would you prefer?
Stay free.
All right, there's going to be intensive outpatient treatment, 90 sober meetings in 90 days. And there will be regular UAs. And he's to continue with ignition interlock until further notice. Yes.
I don't know that it has the interlock. I see that it has the portable device.
Do you have a vehicle?
I have a vehicle, but it's not running.
All right, you need to provide proof of that. And with an affidavit of non-driving and proof of an operable vehicle, then he can do the portable monitoring device until further notice. Is there anything else you need from the court? You better do better. And remember all of the tools that you have been given to not backslide. You understand? People, places, and things, and you have to take accountability. All right, good luck to you in this court. If you need something, you can call probation. If you feel they're not addressing it, you can always come back. All right, where's Anita? All right, let's take your case.